There. Damn. What's going on? Here. Heyo. And welcome back to me, to Nick Storrow's Trial Watch. And thank you. I'm feeling a bit better. My voice still isn't completely up to par, but I have been on streams throughout the week on occasions, and on Friday is the most important stream. So I thought I would give this stream about this subject so I know where the limits of my voice is and everything like that. I'm checking here to see where. Yeah, okay, we are live at Rumble as well. So for you who has spicier comments, I would redirect you to Rumble. The link to the Rumble is pinned at the top of the chat. All right. Hi, Gigi and Sharfos and Debbie and Thomas and Cindy and Wilhelma. Christine, I see you there as well. Yeah, there are a bunch of us here. I hope we can get a few more. And for you who have missed it, the judge has declared that on Friday he will read the verdict. And of course, I will cover that live. So we all finally can get an answer to the question we all have asked ourselves. Did the prosecution do enough for conviction, or did they F it up by, in my opinion, getting too much crap involved? But you never know. Who got you sick? One in 20,000. Last Sunday, I went to a soccer game with 20,300 spectators, and might not have been the greatest of ideas because I'm here at my farm, or I am at work, or I am at my girlfriend's. I don't really go out in public that much, so exposing myself to the germs of a 20,000 audience watching soccer, yeah. But hey, stuff happens, and hopefully, no, it wasn't the vid. It was a normal cold, but it was a man cold, so it's really, really serious. Oh, yeah. So that is what happened to me. So I haven't been able to stream as much as I would have wanted, but I need to save my voice and get healthy, because as for everything else, family, work, farm, then YouTube. That's the order I have to have everything in. And I don't have my normal cup. It's in the dishwasher, so I'm using David's over at Making Law Simple Network, one of his old cups. It tastes good, but not as good as in my own coffee mug. But you can't have it all. Good evening, Naima. Good evening, Naima. All right, we are starting to assemble a few of us here. Yeah, we are here because, or I am streaming this because Mr. Dinkins did a Sarah Boone and wrote a letter to the judge. Yeah, and if you don't know who Sarah Boone is, yeah, David over at MLS Law Show, he has opinions about what she's doing. She just got her 6th lawyer to, no, not doing this anymore. So now she will be on her lawyer number 7. And I don't know if Mr. Dinkins have watched and got inspired by her, but it is 1, 2, 3, almost 3+ pages of text, and I don't know about you, but the handwriting is really good, which I didn't expect, but maybe it's my prejudicials. But how are you all doing? Where are you tuning in from? Because here I am in Sweden. It is 2:30 a.m. And the reason why I am up this late is because I took an afternoon nap that lasted way too long. And when I discovered that, I told myself, instead of doing this tomorrow at 9 a.m. Eastern and 3 p.m. my time, I might as well do it now when it is, I believe it's 7:30 Iowa time and 8:30 Eastern. So I guess there are people at home with nothing to do. Okay, Golden Rules, Davenport, Iowa. Ivelia from Texas. Yeah, Lone Star State. Newfoundland, Canada. Lyons, New York, Charlotte, North Carolina. I mean, Chicago, Seattle, Washington. You're from all over the place. Spartanburg, South Carolina. Oh, Tennessee, Nashville. I mean, you are from everywhere. That is so cool. Imagine that. A bunch of people from all around the place tuning in to watch this 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 old Viking here. Mesa, Arizona. Sal. Okay, I invited Sal because Sal knows a bit about this case too, but he's going to bed soon. Okay, South Carolina. That's interesting because I've been following the Murdoch trial a bit and the shenanigans that's going on there. I might do an update on what's going on there this weekend. That's, jeez. Oh. Twin Cities, Minnesota. Yeah, nice. Okay, but I don't know how long my how long my voice will make it tonight, because I would assume that Friday that may be a lengthy stream, because if Judge Latham is coming to a guilty verdict, is reading out of the guilty verdict, and if he's doing sentencing at the same time, then that will be a lengthy stream, because that would involve victims' impact statements and everything else. But we don't know until Friday. Oh, no worries. No worries. I asked my members, should I cover this trial? And it was majority, yes, you need to cover this case. And if you followed my streams the past 3.5 weeks or something, or 4, no. Well, I made it good, but I've been yelling at the prosecution a lot. And I do so, not because, Jesus, I want this guy acquitted, because please do a better job. I get so infuriated when prosecutions have alternatives to make a better job, but choose a different path. And yeah, Eris asked, I haven't seen a bench trial before. Is it common for the judge to give this much notice before reading the verdict? I don't know. This is my first bench trial as well. I would assume when he announced it on Friday, I think, last week, that he then had the verdict and everything. Then it is scheduling. You have to have the lawyers there, you have to have the defendant there, you have to have the families there. I mean, there's a lot of people, and then it has to fit into the judge's schedule as well. So that might be why he announced it so far ahead. Thank you, Gigi. Everybody say hello to Gigi. She is my first and best mod. Yay! Yay! Oh yeah, and all the YouTube things. Remember to do the thumbs up. Subscribe if you like my content, and if you really, really like my content, please become a member. It's $3 a month, and it gives you members-only content, which is me talking about my farm or my morning thoughts or stuff like that. And you also get access to the Discord, where you can continue discussing the cases I cover after the stream is done. Erin Hack also, does anyone know the verdict before it's announced besides the judge? No. But I would assume that the prosecution will prepare for a guilty verdict by having the people in for the victim statements, if that is what the judge has chosen. He will have the scheduling is presented to the lawyers, but they probably cannot show it to the public. So if he has scheduled the entire morning up to lunch, you would assume that, yeah, it is probably going to be... it's speculation, but the longer it takes, in my opinion, it more shows that the judge has done an amazing job, hopefully, by getting to his conclusion. And then he has to motivate it, because he needs to avoid every kind of appellate issues. There are a lot of laws and regulations regarding both a guilty and a not guilty verdict when the judge is both the finder of fact and the protector of the law, or whatever it's called. We will get to that, Beth, in this stream. We will get to that. Hi, Tracy. Oh, you live across the river from Davenport. Yeah, I would imagine this has been heartbreaking, and Breasia needs justice. She deserves justice, and in my opinion, I don't think the prosecution's case did her right. In my opinion. You can have another opinion, and if you have a very spicy opinion, I have the Rumble stream you can go to, where that chat is... they allow much more spice. And the reason why I do this is because here in Sweden we have a law for publishers that we are somewhat responsible for the commentary, for the comments from the viewers. So I have to be a bit careful. Okay, but we are 15 minutes in, so I think you deserve to see what is going on with this letter. There, add. Let me bring it up to you. Okay, are you all ready? I hope you all can see this. This is from September 11th, when it was... he wrote it September 4th. It was, and it was entered into record on September 11th. Judge Latham, I am writing you with urgency. Attention that the state has used deception and sabotaged this whole case to fit their opinion of a theory, which I have proof, if given the opportunity to show you their lack of honesty to the courts and the public. First and foremost, they, the state, did not obligate the court's order when my attorney filed for request for production and disclose by counsel and pursuant to Iowa Rule of Criminal Procedures, stating the following item of evidence. If in possession and control of the state of Iowa are necessary for preparation, the defendant to inspect copies or photographs or exhibits or any evidence the state intends to offer in evidence at the trial or were obtained from or belong to the defendant. Spelling isn't that good. That entirety without commutation, yeah. But I would assume that he means that the prosecution hasn't obeyed by a court order, by production and disclosure about evidence or testimony or witnesses or something of that sort. Copies of photographs, and here that depends if that actually exists. Yeah, lack of punctuation makes it really hard to read, and not the best grammar as well. Let's continue. Rule this: consequences of failure to make disclosure or discovery. Rule this: failure to disclose or supplement if a party failed to provide information or identify a witness as required by rule that, or this. The party is not allowed to use that information or witness to supply evidence on a motion, at a hearing, or at trial unless the failure was substantially justified or harmless. I'm guessing he is copying from the statute here. D. The failure to act described in rule that may not be excused on the grounds that the discovery sought is objectionable. So that is just, in his opinion, something that the prosecution hasn't obliged to. So it resembles an actual motion, but it's not written by a lawyer. It might be from a jailhouse lawyer. This disclosure of expert testimony in general, in addition to the disclosure required by rule, a party must disclose to the other parties the identity of any witness the party may use at trial to present evidence under the rule of evidence. These rules. Any exhibits that will be used to summarize or support the opinion. This rule, duty to disclose, required disclosure that. I am guessing he is talking about an expert witness having not disclosed or provided the report. I'm not entirely sure what he means here, because he is citing different rules, probably directly from the rules or statutes. In general, except as exempted by rule this, or otherwise stipulated or ordered by the court, a party must, without awaiting a discovery request, provide the other parties all document, electronically stored information, and tangible things that the disclosing party has in its possession, custody, or control, and it may use to support its claim or defense unless the use would be solely for impeachment. This is, I can't say it's cited directly from the statute, because statutes are normally with commas. And punctuation is gone from this letter, more or less. I would have to say, Judge Latham, that the state didn't provide at least 50% of those exhibits until the day of trial. And there are still others the state haven't provided to us, the defendant. Okay, that 50% here is, well, first of all, it looks like he started to say 40%, but changed it to 50% until the day of trial. Well, if true, this should have been a motion about that in trial before the defense rested. If it isn't, it doesn't matter. It is not unheard of that the state waits as long as possible to disclose exhibits, to disclose what they're going to use, to disclose expert witnesses' reports, but so does the defense. Sometimes they don't even write the report for the defense. So, in my opinion, it's wrong, because it should be provided far in advance, so that both parties can prepare for it. And he claims that there are still others. I mean, I assume he means evidence, testimony, reports that the state haven't provided to us, the defendant. That is also up to the defense to bring forward to the judge. And if it isn't, it's gone. MD Thomas says, without specific examples, I don't give this letter any credit. Yeah, he really, in a proper motion, this would have been disclosed. What are missing? Whose testimony is who is the expert? Whose report? What evidence? It needs to be specified. And if he has the, as he said up here, did not, first and foremost, the state did not oblige the court's order. So if there is a court order, then that has to be, if there is a court order that state you have to provide the defense with this, and they didn't until the day of the trial, then it's up to the defense to object to it. And if they haven't provided something that was presented in trial, there has to be an objection on record for that. Now, it might be a standing objection we haven't seen. I know after we all saw the trial that there was different kinds of standing objections. I haven't seen the documents for them yet. I haven't seen those documents or those motions, or why the judge allowed it to be a standing objection. But if there is a standing objection to this, then it is, and the defense haven't explained it to the defendant, then it's on the defense. But if there is these standing objections, then all of this would be in a possible appeal. So all these things that he is saying are appellate issues. But appeals are for losers, and if Mr. Dinkins is found guilty, he will have a really, really hard time getting the conviction overturned, in my opinion. Let's continue here. If given the opportunity to prove this on the records, I can show the deception and how they sabotage a lot in this case. I showed you already where the state moved exhibits to fit their story in trial. Okay. And the state can present evidence out of order. We all saw that on occasions when they had Breisia's mother read into record her phone records, which was really weird, but nobody objected, and that's just how it is. He says, I have plenty more to show you, and the public those exhibits was also giving to us during trial, not before. I don't know. Again, as you in the chat discovered, if it doesn't give examples, then there's nothing that can be done about it. If it doesn't give examples about this, I have plenty more to show you, and the public those exhibits was also giving to us during trial, not before. That has to be in through the lawyers. That objection, Your Honor, we were not aware of this, and I do believe that happened on 2 occasions during the trial, and they had some form of in the breaks, though that was discussed. So that is probably objected to on the record, and the judge let it in. If convicted, it's an appellate issue. And here, rule this grounds for vacating or modifying judgment, unavoidable casualty or misfortune, preventing the parties from prosecuting or defending. So vacating or modifying judgment, I would assume he is asking for either vacating a possible judgment or modifying it to a lesser charge. Unavoidable casualty was preventing the parties from prosecuting or defending. Rule this material evidence newly discovered, which could not with reasonable diligence have been discovered and produced at trial. That is for if he is convicted. The next stage, the appeal, is only about if the prosecution and the judge made mistakes that could have affected the outcome. The appeal after that is about, okay, we discovered this, but it also, as with the Murdoch trial, this should be entered after a possible conviction, not before the verdict is actually in. He can't produce, the judge can't do anything, even if the lawyers have submitted this. This is something that has to be after a possible conviction. If it's newly discovered, which could not have reasonable diligence have been discovered and produced at trial, then that would be a motion for a new trial, I assume. I'm not that familiar with Iowa rules, but if it is somewhat the same as in South Carolina, there is when this motion that he's trying to write would apply. He continues with, Judge Latham, I was also looking under official comment, enactment 1943 federal practice. We come now to the question of enforcement without adequate sanction. The procedure for discovery would be ineffectual under Rule 37, and party who seeks to evade or thwart a full and candid discovery incurs the risk of serious consequences, which may involve imprisonment for contempt of court for disobedience of court order. Oh, this won't happen. Let's continue here. The entry of order that designates facts be taken to establish the entry of any refusing the disobedience party the right to support or oppose designated claims of defenses, strike out pleading by default dismissal. I don't think he is copying that rule completely correct, but what he is talking about here is if this disclosure wasn't fulfilled and evidence was presented during trial that was new to the trial and to the defense. This is up to the defense to object about, and if it is deemed misconduct to that degree, the judge has the power to provide sanctions. That is a completely different motion that should be handled during trial. And to my knowledge, none of that was provided. And the defense has rested. So if anything, any possible misconduct, that would be for a motion after a possible conviction. And you over at there are a bunch of you watching from Rumble. Please put something in the chat so I know you are there. Yeah, as I said, this, since it wasn't in the actual, they didn't provide a motion in the actual trial, then this is gone. It could possibly be an appellate issue. But he's mixing, asking for a new trial, vacate a possible eviction, which you can't do before there is an actual conviction. He is mixing different, so I would assume this is not, it can't be via his lawyers, because then it would have been an actual motion, which they may not have agreed to, because there are so much procedural mistakes in this letter that assumes guilt, that he assumes he will be found guilty. So more or less all of what he is describing, if that actually happened, then that would be either for appellate court for procedural mistakes or for asking for a new trial. But I can't see that happening if he is convicted. And okay, that is the letter. Okay, that is the letter. And yeah, I would assume that this is a letter that he had help with in jail from a jailhouse lawyer. Not an actual lawyer that is there, but someone who has access to the statutes, who has access to all the thingies, who helped him write this letter. But procedural, it's a mess. And as I said, he's asking for vacate of conviction, but he isn't convicted yet. He is asking for sanctions that should have been during trial, not after the defense rested. Now, of course, the defense have the option to actually submit such a motion to the court, but I assume since he wrote this himself, they wouldn't. And that would tell us all everything we need to know about this letter. That he wants something that his lawyers can't provide. It's as simple as that. He is asking for a lot from his lawyer. And during trial, I had some criticism about the defense, but his defense lawyers were good, really good. They had something to. They had a bunch of things to work with, and they did the best with that. So if they didn't help him with this letter by submitting a motion, I would assume they have advised him, no, Mr. Dinkins, you can't submit this as motion because you aren't convicted yet. Yeah, this is from the Darrell Brooks way of handling things. Yes, Oline Ryan. Someone helped him with that. Okay, I see Rumble, Slidey Pie, and Ghostery is over there. Hi on Rumble. Hi on Rumble. Naimahal says he's guilty and Darrell Brooks assisted. Well, until the judge is done, we have to assume innocent unless proven guilty. And as I said during my streams, I believe that he did it. But believing and proving are two different things. Golden Rose Ismail chatted with his defense team the whole time. Yeah, that is right. He gave no defense. He doesn't have to. He lied to everyone the day he did this. We don't know. And yeah, he lied on a few things, and that speaks against him. And as I've said during my streams about this, there are proper circumstantial evidence in this trial that leads me to believe he did it. Some things that cannot be explained away, like what was Breasia doing outside his car, and why was she missing once the car was gone? To me, and that in itself is somewhat self-explanatory. What I don't understand is why they didn't submit to testing DNA from inside the car. It would have been so easy. It would have been really easy because she never been in that car. When he drove them from Grandma's place to Andrea's place, he used another car. There is no reason for her DNA to be in that car. But they only tested for bodily fluids and blood. For me, that is amazingly bad. And we know that from the Mr. Pfeiffer's testimony that he wanted to. But upstairs said no. And I don't know why. Maybe they believe, no, it's enough to put her outside the car. And maybe it is. But it's a $500 test. Vacuum the inside of the car, test the contents, there's her DNA, boom, she was in the car. Now we have him on kidnapping. Slam dunk. No need to make the assumption. And other things that was in this trial that I've said this before and I will say it again, using DL's testimony to that extent was not necessary. They could have used him as a corroborating witness for the things they could actually prove. You were at Walmart. Yeah, DL says the same thing. You were there. Yes, DL says the same thing. You went there. Yes, DL says the same thing because you have phone data that supports it. You have the cameras that supports it. All of that is great. But then when DL says he witnessed the actual murder, And the prosecution, in the prosecution's case, he cannot have witnessed it. Because all this happened before he picked DL up. The kidnapping and the murder, according to the prosecution's case. In my opinion, that was a mistake from the prosecution. It was too easy for the defense to insert doubt. And in my opinion, the prosecution should never make it easy for the defense to insert doubt. That's a good catch, Roddy. We all know he's guilty, at least I think so, in my opinion. But even in this letter, he never states he's innocent. Good catch. Good morning, this way up. Yeah, and again, YouTube things, thumbs up, subscribe, hit that bell, share if you have a social media account and you wouldn't mind. I would much appreciate it if you shared this on a Twitter/X or something like that, and stuff that. Let's see if I have questions that I missed here. No, the verdict isn't in yet. It's on Friday, 9:05, according to the judge, on Friday, Iowa time. So 10:05 Eastern time. I will start my stream on Friday on 9 a.m. Iowa time. Because that gives us room to discuss it, because no time in the actual trial they started on time. So, yeah. That gives us some time on Friday to just hang out and chit-chat. And remember Breasia, for despite the way she grew up, she, by all accounts, she was an amazing kid. She could have grown up to do great things. She deserves justice. And if the judge finds Mr. Dinkins guilty, I would understand that. But my biggest fear is that the prosecution inserted too much crap that could lead to reasonable doubt. I will give you an example. Originally, when this still was a jury trial, they calculated for a 5-week trial. Then Mr. Dinkins opted for a bench trial. Then the prosecution cut their case more or less in half, 20 days. And once concluded, they only needed 15 days for this trial. And yeah, for me that says that the prosecution was aiming for a jury trial with much more emotion, and that they might not have been able to switch gears from jury trial to bench trial. Cindy Lawhoot, that poor child was trying to get justice for his sister any way possible. Yes, I agree, but having him on the stand, I mean, one of the first questions on cross-examination was, you would say anything to get to your dad. And he answered yes. And on cross, apparently on direct, he said some things that nobody has heard before. And for a kid trying to help in any way possible, that is why you should only use kids as corroborating evidence, not as a key witness. Because Oh, and I feel sorry for all the kids involved. Breasia, DL, the older brother or sister. I feel bad for them, not only because they were subjected to this trial, but the prosecution kept doxing his name. I mean, it's not hard. You agreed beforehand. Do not say his name. Address him as DL. It's not hard. But that prosecution lady kept doxing him. Now, it's not hard to find out, but in court, in transcript, in record, he should be only presented as DL. And the prosecution ruined that within seconds. And regarding the prosecution, apparently this was her first major trial. She took office. She has been an assistant district attorney for some time. But this was her first major case as a district attorney. She took office in November of last year. Yeah, they need to be protected. I mean, over here in Sweden, you can't interview a kid the way he was interviewed in this case. There has to be specialized interviewers. And even if a cop has special education from the Special Victims Unit, that doesn't apply here, in my opinion. There should be a psychologist or psychiatrist trained on this alone to interview, who can sort through BS, who knows the questions. And once they knew that that DL has been eavesdropping and provided later statements with something that Detective Pfeiffer, and Detective Pfeiffer said on the stand he didn't put much weight on DL's testimony after Pfeiffer submitted information to Aisha. So in my opinion, anything he said up to that point, yeah, that we know he didn't have much influence on. But after, we simply don't know. And we know that from the cross-examination of him, that some things he said could not have happened. He testified that he saw his dad and Andrea commit this crime. And the prosecution and the investigators ruled Andrea out completely. It was too easy for the defense to insert doubt when the prosecution used him as a key witness. And as Gigi said, he got caught trying to listen into court when Andrea was testifying. Yeah. You can see that when the camera panned out. That was a shadow behind that door. And they were quite quick to remove him from the door. But that only shows that he really, really wants to do Breasia justice. And I understand why. Because this was testified to in court. That it was more or less him who made the choice who got with him in the car. The amount of guilt on that kid. Jesus Christ. I mean, oh. Yeah. And as online read saying, I think it needs a lot of therapy, is probably not getting. Yeah. Now, apparently, Aisha has turned her life around since then. And I applaud that. I really do. And I guess Andrea as well turned the life around, I would assume. Who were here during my reading of Mr. Dinkins' rap sheet, you know, geez, from 1994 to 2021, 98 inserts in the record on his rap sheet. There was a bunch of traffic tickets, drug use, drug possession with intent to distribute, other charges. Then you have him with his when he entered the registry, so to speak, as a 17-year-old, and this is infuriating to me. He violated the code he needs to oblige to, according to the registry, 2003, 2004, 2007. 3 times he violated his the way he needs to conduct according to the registry. That for me says he can't stay away from kids. And that for me, okay, thank you for trying. You're done. But throughout his criminal activities, he's a career criminal. And those 98 inserts in the record, that was in Iowa alone. He still has charges in Illinois and entries in Illinois above this. That's just 2 states. Where else have he been doing shit? Doing crap. His last entry from 2019, and one of his last before this happened, he got a 5-year sentence. He was out after 5 months. And rumor says it's the same person who kept letting him out the last couple of 3, 4, 5 years. He got a sentence for a year, 2, something like that. Couple of months, 3 months, 5 months later, he was out on the street again. Yeah. The Illinois records show many OP for domestic violence. Yeah, he violated in his Iowa record. He violated a bunch of those too. And it's infuriating. Had anyone just said no, enough is enough, Breasia would still be alive. The entirety of the justice system failed Breasia. The entirety, top to bottom. The amount of charges he had, every cop in that area must have known about him. All of them. And he kept getting away with everything. All right, now we have spewed enough about Mr. Dinkins. Let's look at what the judge ordered. All right, everybody ready? In the Iowa District Court for Scott County, plaintiff, defendant sent a letter to the undersigned on 9/11/2023. Defendant is represented by court-appointed counsel. Pursuant to Iowa Code Section this, a defendant who is currently represented by counsel shall not file any pro se document except for a motion seeking disqualification of appointed counsel. The clerk shall provide a copy of this order and defendant's letter to all counsel of record. Defendant's attorney shall confer with defendant to determine whether any motion should be filed and set for hearing. Defendant is advised to work through court-appointed counsel. Defendant is further advised that everything defendant files shall and will be provided to all counsel of record, including the prosecution attorney, and that the court cannot consider pro se filings other than a motion seeking disqualification of appointed counsel. All above ordered, this 11th day of September, the clerk shall notify all attorneys of record. Signed, Honorable Judge Henry W. Latham II. Yeah. So, it is, as we discussed earlier, the court can't do anything by a pro se motion, since he has an actual lawyer. And I would assume that Mr. Dinkins tried to have his lawyer submit this, and they couldn't because he is not convicted yet. There's no verdict yet. And so asking for sanctions, asking for revoke of judgment, asking for blah, 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 all of that, completely useless. Completely. But it also, here's the thing, this is things he might have discussed with his lawyer. What happens if I get convicted? And now the prosecution can prepare for it. So he might just have undermined his own possibilities for appeal. So if the judge has decided his fate prior to this letter, could he change his mind? I would assume no. The judge in this trial, by all accounts, conducted himself according to law. And as the finder of fact and the finder of law, then I don't think he just... Speculatively, what happened? The clerk received the letter. She told the judge, Mr. Dinkins has sent you a letter. He's asking for a bunch of things. And the judge told the clerk, okay, I can't... He has a lawyer. I can't do anything with it. And then the clerk wrote it up. The judge read through it, signed it, and entered into record. That is what I assume happened. And over at Rumble, 13 watching. Okay. And why haven't you? And 8 of you had pushed the thumbs up on Rumble. Hey, get it up to at least 13, 14 watching now. That helps the channel. And 3 more followers during this stream on Rumble. That's good by Rumble standard. Now, why do I have Rumble? Well, some of the trials I'm covering can get gory, and YouTube really don't like gore. Even though other channels are, Law and Crime and Court TV, but apparently they have different rules than I have. And so this stream here now, for example, you either have a green, a yellow, or a red. I got the yellow sign quite fast, so I get no ad revenue whatsoever as long as it is on yellow. So that and if YouTube suddenly decides, no, you were too gory on those streams, they can just yeet me. That is why I'm also on Rumble. So if for some reason YouTube decides that I'm not good enough for YouTube, I have the beginnings of a platform over at Rumble. That is why I am on both platforms. Yeah, especially Serial Killer Sunday. I can't even, yeah. Serial Killer Sunday. We are currently on Sunday, we will conclude the Jeffrey Dahmer trial. And on a few of those, YouTube put me in the red. That I'm not allowed to make money. I'm that close to violating the TOS. And that is why Serial Killer Sunday nowadays is on Rumble alone. Because even though I wish I could submit this to a wider audience through this channel, I can't. I can't risk my channel. I have too much to say, too much to explain, too much to talk about for me to risk this channel for Serial Killer Sunday. So that is Rumble exclusive from now on. Okay. Do we have... Oh, no worries. That is why I'm here, because as you understand, I'm not a US lawyer. I'm based in Sweden. So, but my understanding of law, because I'm trained in evidence evaluation, I'm trained in all of these factors, I do have a better than layman understanding about law. And that is why you and me are learning together. And since I'm not trying to be a von Oben or something like that, but as I learn, I can explain to you. I think that benefits us all. Judge can't go back on his words. If he is decided on guilt or not guilty, this letter doesn't matter to him at all, I would assume. Dun, dun, dun. Do I have any? Oh, Ghetto Gamer. He's from he or she is from Iowa. Okay, then and he or she, I don't know your gender. He or she, at least. Ain't no way my daughter would have went over there. Yeah, here's the thing. It seems like he fooled everyone, or at least the grandmother, that he was somewhat of a good guy. But then we also know during his relationship with Andrea, during his relationship with Aisha, career criminal, drugs, cars. I mean, I don't know. Yeah, but this case is so infuriating, because this case, it's so unnecessary, because had the justice system worked, Breasia would still be alive, because Mr. Dinkins, no matter the outcome of this trial, should not be around in public. And in the odd chance that he is not convicted, he has 6 pending charges in Iowa for violation of his rules regarding him being on the registry. Those are up to 10 years each. So I would assume if he is found not guilty, the prosecution will just go, here, these are. And he's 51 now, or something like that. And if they say you can get 60, we 40 as a plea deal or something, then he's put away for the rest of his life anyway. And I hope that would be the result if he, for some reason, gets acquitted for these crimes, that they will put the hammer on the rest of it. And he still have pending charges in Illinois. So no matter what happens here, I hope that the justice system finally brings justice and put him away for the rest of his natural life for his other charges. Oh, okay. I can feel my voice is beginning to give up on me. So I will do like this. I will see who I can redirect you to. Is there nobody? Let's see here. I will just go out on YouTube and see what is up later. Okay, Runkle of the Bailey is starting his stream at 4 a.m. about the New Mexico gun ban. So I will send you over there as a redirect. Dun, dun, dun. And I see that over at Rumble, I'm up to 9 thumbs up out of 12. So that's a good result. How are we doing here? We are 62 out of 7. Yeah, it's a decent result. I hope on the way out you can hit that thumbs up. And I'm glad to be back. I'm glad that my voice is holding up somewhat. And thank you all for showing up. Thank you for allowing me to explain what is... oh, it's Kaiser Pineapple streaming. Oh, Kaiser is... But I don't know if he... Let me see here if I can... Yep. Oh, Kaiser Pineapple is live. So it will be Kaiser Pineapple that I will be... It is about the Mexico UAP congressional hearing and disclosure. So UFO aliens. That would be a nice palate cleansing from this. But again, thank you all for showing up. Thank you all for allowing me to relay this information to you. I hope I will see you all here on Friday for the actual sentencing. Thank you all. Have a nice day. And I'll talk to you all later. Bye-bye.